There's been a steady rise in England and Wales in so-called freemen on the land or sovereign citizens, claiming that laws only apply to them if they consent to them. Now, they're all based on invalid legal arguments, and on several occasions they've resulted in fines and other legal trouble for those who attempt to use them. Indeed, I did a short video on freemen on the land last year, and the feedback from that was overwhelmingly positive. Now, the reason I'm doing this video is that the people saying things like you can refuse to pay council tax because it is a contract and not a law are talking absolute nonsense and have no legal basis for saying anything that they are. And worse than that, they are not going to face the consequences of the so-called advice that they are giving. But you will be caught out by it. Now, if you're unsure of something or you see something on social media and you think, I'm not really sure if that's right or not, then a quick Google search will give lots of information, including from the government's own website and other legal professionals who debunk this so-called pseudo-legal nonsense. Be smart and do not get caught out by it. Otherwise, you will unfortunately have to face the consequences of this terrible, terrible advice. What I'd like to do in this video is just talk very briefly about a couple of examples or a couple of the arguments that are put forward by the freemen on the land claiming to act in defiance of the law and why they are simply wrong. Now, in order to do so, what I need to do firstly is explain a couple of basic legal concepts that are often cited by the freemen on the land. Now, the first one is common law. Now, the simplest definition for common law is that it is a body of law based on court decisions rather than codes or statutes, i.e. Acts of Parliament. And an example of common law in action is the Offences Against the Person Act 1861, whereby offences relating to different types of assault have been set out in statute, but specific definitions have been detailed in subsequent court decisions and are part of the common law. So as an example, the definition of grievous bodily harm is not defined in the Offences Against the Person Act. That has developed under the common law as outlined in the case of the Director of Public Prosecutions and Smith from a case in 1960. The thing about the common law is that when an Act of Parliament is passed which contradicts, changes or amends the common law, then the Act of Parliament becomes the law and the common law for that specific definition or thing in law ceases to exist. But there's no such thing as the common law as a concept on its own. The common law refers to a number of different cases relating to specific legal points that have developed over the years as more cases come before the courts. The second thing that I want to talk about is Magna Carta, and this is often cited as a means of defying the current and established law. Now, Magna Carta was issued in June 1215 and was the first document that put into writing the principle that the king and his government was not above the law. It sought to prevent the king from exploiting his power and placed limits on royal authority by establishing law as a power in itself. Now, it had 63 clauses in it originally, but the overwhelming majority of these clauses have been repealed, and there are only 3 clauses left which are extant: the freedom of the Church of England, the ancient liberties of the City of London, and the right to due legal process. Everything else in it has been repealed and is no longer part of the law of England and Wales. The final thing I want to talk about is something called Parliamentary Supremacy. Now, the agreed and widely accepted definition of parliamentary supremacy comes from A.V. Dicey in an introduction to the study of law of the Constitution, 1885. And he states that the principle of parliamentary sovereignty means no more or less than this, namely that Parliament has under the English Constitution the right to make and unmake any law whatever, and further that no person or body is recognised by the law as having the right to override or set aside the legislation of Parliament. So what this means in practice is that Parliament can pass whatever legislation it likes and can introduce or repeal any law as it sees fit, and that no other person or body can change or repeal legislation which Parliament has enacted. In particular, this means that the courts must uphold legislation passed by Parliament and cannot declare legislation to be unconstitutional. Now, you might contrast this to the position in the United States, where the US Supreme Court can strike down an act of Congress as being unconstitutional. And you might have heard of some acts of Parliament being declared incompatible with the European Convention on Human Rights, but this is different to being ruled unconstitutional. Courts in England and Wales have no power to declare an act of Parliament unconstitutional. So now that I've explained what the common law is and the impact that Magna Carta has on the law of England and Wales, spoiler alert, very little, and the fact that Parliament is supreme and can make and repeal any laws as it sees fit, I'm now going to talk about a couple of examples of where the freemen on the land have tried to exercise rights under Magna Carta or by stating that a specific law does not apply to them. So the first example we're going to look at is a hairdresser who claimed under Article 61 of Magna Carta that she had a right to keep her business open. Now, if we rewind back to the lockdown during the COVID-19 pandemic, everything was closed and businesses were not permitted to remain open unless they fell within one of the exceptions outlined by the government. Hair salons at this time were not permitted to remain open. Now, a business owner called Sinead Quinn owned a hair salon in Oakenshaw near Bradford and attempted to keep her shop open during lockdown, putting a sign in the window declaring that under Article 61 of Magna Carta, this allowed her to opt out of the law that she does not consent to, and she is able to enter into lawful rebellion in accordance with that specific clause. And Miss Quinn defended her action, saying that she had a right to earn a living, gaining support amongst the fringe anti-lockdown campaigners. Now, there's two problems with Mrs. Quinn's argument. Firstly, there is no mention of lawful rebellion in the clause itself. The clause is intended to give rights and powers to 25 specific barons for the application and observation of the Charter, mainly to ensure that King John was complying with Magna Carta. And secondly, even if the clause did say what those who claim its protection say it does, it was repealed in 1216 when Magna Carta was reissued. So on both counts, Miss Quinn, no doubt led by those giving advice which would not have affected them, therefore has no right, certainly under Magna Carta, to ignore the COVID lockdown laws that were in place at the time, and as a result she was fined nearly £20,000. Another favourite of the Freeman on the Land movement is that you can refuse to pay council tax on the basis that you are only bound by contracts and laws that you have consented to. But the first thing to say is that council tax is not covered by contract law. It is a statutory requirement set out in an Act of Parliament, and Parliament being sovereign, as I've already outlined. The specific Act of Parliament is the Local Government Finance Act 1992, and if you meet the criteria for paying council tax under the Act, then you do not have a choice as to whether or not you are liable for council tax, and being a freeman on the land does not exempt anyone from paying council tax. The Local Government and Finance Act 1992 is a statute created by a democratically elected Parliament of the United Kingdom, which has received the assent of the Crown, and the subsequent statutory regulations set out the local authorities' rights to demand council tax to fund services and who is liable to pay. Now, your liability for council tax is not dependent on and does not require your consent or the existence of a contractual relationship between the council. Any such assertion to the contrary is incorrect, and there is no legal basis to make the argument that you don't consent or haven't entered into a contractual relationship. Anyone who does withhold council tax is likely to face recovery action, and in extreme cases this can even lead to a prison sentence, such as in the case of Manchester Magistrates Court and Mackenzie in a case from 2015, where an individual attempted to use similar arguments under Freeman of the Land and ended up in prison for 40 days. To summarise this video, what I really want to get across is that I and the overwhelming majority of legal professionals in the UK who are qualified and experienced will tell you that the arguments put forward by the Freeman on the Land movements are complete and utter nonsense and have no legal basis and will not stack up in court. Now, if you're very hard over and you think, actually, Andy, you're talking absolute bollocks, this stuff is real, then what I suggest you do is test your argument in court, and I guarantee you that you will lose. So my advice, especially for people who are seeing stuff about council tax and not closing businesses on social media, is take it with a pinch of salt. And as I said at the start of the video, do a quick Google, do your research, and you will see the overwhelming majority of people will tell you that the stuff peddled by these snake oil salesmen is utter nonsense, and they won't suffer the consequences of the advice they're giving out. You will. That's it for this video. If you do have a comment, please drop it down below. Based on my last short that I posted, I'm sure there's bound to be some contrary opinion, so I look forward to reading that. If you did enjoy this video, then please do give it a like, and if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.